record. Okay, so now this is the second part of our lecture on the topic damages. The first part we discussed about the rule, okay, the principle relating to damages. Now we are discussing about kinds or types of damages. And altogether, there are 6 for us to finish the discussion. Okay, and then for all the 6, usually I will ask students to identify, okay, which one is compensatory, okay, in the nature of to give compensation, not because of other objectives or aim of the damages. So we have general, special, exemplary, aggravated, nominal, and contemptuous. So for today, last time, we discussed briefly about contemptuous damages, but we haven't finished the discussion. So let me just refresh again. So what is contemptuous damages? From the word contempt. Okay, so usually it consists of the award of derisory, very, very small amount, okay, that you can laugh at, laughable sum, smallest coin of the realm. So in Malaysia, maybe 5 cents is the smallest coin. So what's the purpose of awarding this kind of damages? So usually it is awarded because plaintiff's action, although technically he is successful, I mean, he won the case, but the court found that it was without merit. And the court actually was of odd opinion, okay, was of the opinion that it shouldn't have been brought at the first place. I mean, like here, maybe plaintiff just bring a bad claim. And most of the time, this is, you can see this contemptuous damages, which is awarded by the court in the cases relating to libel, okay, assault, and false imprisonment. Okay, we are going to discuss all these intentional torts later. And we have 2 cases. We have, this is common law, Pamphlet and Express Limited, Express Newspapers Limited. You can read later in your textbook or anywhere. But we are going to discuss Gucharan Singh today. And basically, when we talk about, is it compensatory? Is it non-compensatory? Because the amount, it doesn't reflect compensation. So obviously it is not compensatory. Because why? It is awarded because the court is not happy, okay, with the plaintiff's action of bringing the suit to the court. Okay, what happened in Gucharan Singh? Gucharan Singh, this is the full citation. Okay, you can find it in all Malaysia reports as well as in CLJ. Okay. Gucharan Singh and penguasa tempat tahanan perlindungan Kamunting, Taiping. So plaintiff here, Gucharan Singh, he was detained under ISA, the old, I mean, it has been repealed, okay, this particular act here, Internal Security Act. And he was detained for a period of 2 years. Usually that's the first period, and then it could be renewed, okay, for no limitation. I mean, for perpetual. I mean, you can be, the person can be detained forever, in a way, technically, okay? Because what's the reason here? What's the allegation? He was trading military secrets, okay, relating to Malaysian air defenses to a neighboring country. So which is very, very serious offense here, the allegation. And then later, okay, after 2 years, in 1991, the detention was extended for another 2 years. So it's 2 plus 2 plus 2, okay? But the problem is that this extension order, it did not state, okay, it did not contain the reasons for the extension. So certain problem, I mean, procedurally, it was wrong, okay? I mean, there's some technical problem here. No reason why it was being extended. And later, if you read the case, actually he was released later lah. So that's why now he is suing government. Okay, he said, oh, he was being falsely imprisoned. So plaintiff claimed damages, the compensation for false imprisonment not from the very beginning, from the period of 1991 to 1993, the extension, okay, the extended period. And he argued that, okay, because there's no reason, okay, absence of reasons for this extension period, it caused the detention unlawful, meaning that here he was being unlawfully imprisoned, detained here. And then he also sued the Deputy Home Minister, okay, as a second, and the Malaysian government. So he's suing everyone, okay. He sued Malaysian government as the third defendant, okay. So all the parties here as the defendants. So the court said, yes, you have the right, and actually you are right, okay. You won the case technically. So the court held that the plaintiff action in suing the government, okay, was deplorable. I mean, it is worth severe. It's not condemnation, severe. I mean, very, very serious here. Severe condemnation. And the court actually was displeased, okay, displeasure, attracting the court's displeasure. So yes, you won the case, but then we only awarding you 1 ringgit coin only. Okay, those days we have this 1 ringgit coin in gold color. Okay, 1992. You can see that's the picture that I Googled. You were not born, obviously, okay. But now we don't have this coin anymore. Okay, that's about it. I mean, we have one common law case you can read on your own, and then we have one local case to discuss or to illustrate about application example of contemptuous damages. Okay, the next kind or type is nominal damages. So nominal means small. I mean, the term itself can give you some ideas, okay, what it's all about. So what is nominal damages here? Nominal damages is only allowed in torts that are actionable per se. Okay, certain torts are not actionable per se. Torts which is actionable per se is that the moment it is being committed, okay, we don't care whether the party suffer injury or not. Okay, so in cases of injuria sine damno, that's the Latin phrases, which means there was an infringement, okay, of a legal right, plaintiff legal right, but there was no actual loss to the plaintiff. No injury, no losses, no damage suffered by the plaintiff. Okay, so in other words, a wrongful act has been committed. The torts has taken place. And it was committed by the defendant. But as far as the plaintiff is concerned, plaintiff has not suffered any actual damage or loss. But can plaintiff go to the court? Can file a suit? Yes, can. Okay. So because of that, plaintiff only receive a small sum of money in recognition, okay, to recognize that yes, your right has been infringed. Okay, we agreed, but then we cannot give you a big amount of money. So again, okay, nominal damages are under the category of non-compensatory because just a small amount of money. So it's not really meant to compensate. I'm admitting Nubini Adriana. Okay, we go to the next slide. Okay, we have a case here, a very old case, common law. I think some of you are quite familiar with this case, kan? I remember when I'm not sure whether the syllabus has been changed, but when I was in matric, those days, long time ago, 1990. In matric, long time ago. So I learned this case during matric, okay? Not during, it's quite famous case lah. Constantine and Imperial Hotels Limited, 1944. Okay, what the case is all about? So who was the plaintiff here? Plaintiff, he was a famous West Indian cricketer. Okay, the sport of cricket, kan? Usually in Hindi movie, we see this sport, kan, cricket. But I think not really famous in Malaysia, okay, not really common. So now, defendant is they were the hotel owner. Okay, defendants, they refuse the plaintiff accommodation, meaning that, oh, you cannot stay here at one of their hotels, to which the latter wish to go, meaning that here defendants had chains of few branches, but then nevertheless defendants provided him with lodging accommodation in another of their hotel, not that particular branch of hotel. So plaintiff felt annoyed lah, basically. That's why he filed a suit here. And then he won the case. But the court said, yes, because you still get the accommodation eventually. Okay? It will be different if he was denied accommodation at all, right? So in this case, the plaintiff was entitled to nominal damages just to recognize that his right was being infringed, okay? How much is the amount? Very small, the coin here. 5 guineas, okay, as he suffered unjustifiable humiliation and distress when he was denied the accommodation of his wish. If you read the case, it is everywhere, okay, if you Google, but those days in UK, it happened in UK, it relates to racism here, but those days, racism was not something which is illegal. That's why he just got on the nominal damages. Okay, you can read lah. It's always a problem with racism, okay? So that's about it for nominal damages. We only have one case. We can have more, but this is just a case to illustrate application of nominal damages. Okay, the next one, exemplary damages. Okay, I think, is it from the word example? Okay, exemplary damages. I mean, damages is awarded to give example to others. And then as far as the nature is concerned, it is punitive in nature, to punish. Okay, punitive relates to the word punish, punitive damages. So again, is it compensatory or is it non-compensatory here? Okay, all right. So what's the reason? Okay, what's the objective of awarding exemplary damages? Usually, the main reason is the court wants to deter the defendant from repeating his act in the future. So now the focus is on the conduct of the defendant. And then it can be awarded together with other damages. Okay, awarded in addition. On top of general and special damages, plaintiff can also get this exemplary damages. But again, okay, because of the nature, the objective is to punish, kan, punitive. So the scope is very, very limited. And another thing, it must be pleaded. The court won't simply allow you if you don't ask for it. You must ask for it. I mean, plaintiff needs to really plead, ask from the court to be awarded with exemplary damages. If the plaintiff didn't plead, then there's no way that the court will simply award this kind of damages. Okay, we have, this is leading case actually, the case which established the rule. Rooks and Barnett, 1964, this is appeal case, common law. And the judgment of Lord Devlin here is very, very important. Because why? He said that, this is in connection with exemplary damages. He said that the exemplary damages in principle, okay, it is objectionable. I mean, generally it is something which we could object. Because why? This kind of damages, they confuse the civil and criminal function, because normally civil shouldn't have function of punishing, okay, punitive in nature, no, okay. That's why we just only allow this kind of exemplary damages here in 3 exceptional circumstances, situation, very, very limited, okay. I mean, it's not applicable to all, only 3 exceptional situations or circumstances. Okay, the first one. So this is taken from Rooks and Barnett. Okay, the first one, where the plaintiff has been a victim of oppressive, arbitrary, or unconstitutional act, okay, of whom? Servants of government. Meaning that here the defendant is the servants of the government. If private sector, then cannot apply this exemplary damages for this the first exception. So we have the case of Fong Chi Chung and Inspector Muhammad Nasir. So obviously you can see the Inspector Muhammad Nasir, so he's servant of government. And in this case, the ratio is that, do we follow the Rooks and Barnett? Do we follow common law approach here? Yes, we do. Okay. So in this case, the Malaysian court expressly followed Rooks and Barnett. So we only allow this particular damages in 3 exceptional situations. We are going to learn this case again when we discuss about trespass, I think. Trespass to goods later lah, all right? Okay, the second exceptional situation, okay, where the defendants act, there should be apostrophe, can, defendants act has been calculated by him, I mean, defendant has in mind, okay, to bring him profit which exceeds the amount of compensation that he has to pay to the plaintiff. So, I mean that here, he said, okay, it's okay, I committed tort, but later if I were to pay compensation, still I'll get some profit. I mean, the amount is lower compared to the profit that he's getting. Okay, so it's very specific situation. So we have local case here to illustrate this particular rule. Sin Hip Lee, Marubani, Siram Berhad, and Yip Shou Shan, okay, are reported in 202 in MLJ. It is pertaining to trespass to land. Okay, this is one of our topics later, trespass to land. And in this case, okay, we zoom to the amount of damages. The trial court awarded 3.2 million, big amount of money, okay, for, this is total amount, for compensatory damages, and exemplary damages alone, I mean, the amount was RM 900,000, almost 1 million. So you can see it's very big amount, okay. And then the appellant appeal against this amount, the decision, but the appeal was dismissed. Because why? The court said, well, the conduct of the appellant in this case can not only calculated to result in profit, but also total disregard to their neighbor. So remember, it has element of punishment, okay, to punish the defendant for this conduct. So yes, punitive in nature. I mean, here the amount is very, very huge, okay, very big amount here. And the third exceptional situation related to defamation. So in cases of defamation, where the publisher, okay, of a book or whatever thing being published had no genuine belief in the truth of what he published. So yes, the court may allow, okay, the pleading of exemplary damages. The leading case for common law here, Castle and Company Limited and Broom. Okay, Broom with E here, 1972. So it relates to defamation. And in this case, defendant, he realized that, okay, the profit which he would obtain from the sale of the book would be more than to compensate for the amount of damages that he has calculated from the very beginning. Oh, damages usually 1 million, but the profit will be 5 million. So no problem with that. So because of that, in this case, 1972 case, the court awarded 15,000 pounds sterling, okay, for compensatory damages, and for exemplary damages, 25. So bigger amount, okay, huge amount here. 25,000 pounds sterling, okay, for exemplary damages alone. So altogether total 40,000. So it's, I mean, this is something which is serious. We want to deter. Okay, we don't want this the similar case to happen. We want to deter defendant. We want to punish defendant. We want to deter other potential defendant. Okay, so only 3 exceptional situations. So we are done with the exemplary damages. We are going to move to the next type of damages, aggravated damages. So it is awarded when plaintiff, from the word aggravate, okay, aggravate. So awarded when the plaintiff has suffered losses other than pecuniary loss. Pecuniary loss is something related to money, monetary loss that we can compensate. But certain thing other than money, it relates to feeling usually. So for example, feeling ashamed, loss of reputation, okay, that one, it falls under aggravated damages. So similar to exemplary, it must be pleaded here. And then when the court consider whether it should be allowed or not here, okay, the court will take into account defendant's motive, okay, the reason why it happened, okay, and the act when the tort was committed. And again, it's not really to punish here, but now the focus is on the plaintiff, okay, not to punish the defendant so much, of course lah. At the same time, it could be, okay, but then the focus is on the mental distress, to compensate mental distress of the plaintiff, okay. And again, similar to exemplary, it is awarded in addition to general and special damages. The amount could be very big, okay, because the feeling here, okay, we can't really quantify how much when you feel ashamed, is it 1 million or is it 2 million, your humiliation here, okay, or loss of reputation here. And it is compensatory because even though we cannot really quantify, but it relates to feeling ashamed, mental injury, so it is compensatory. Okay, we have 2 cases. All right, aggravated, but then sometimes, remember, the plaintiff could be awarded with more than one kinds of damages, general, special, exemplary, okay, as well as aggravated. They all can go together, but must be pleaded. There must be reason, okay, for the court to allow the claim for this kind of damages. So we have 2 cases to be discussed for today, both local cases, but very, very important. The first case is, the name of the case is Roshairi Abdul Wahab and Major Mustafa. That's the picture, okay. Ragging lah, basically bullying, ragging here. Another one is about batik, Utusan Melayu and Janting Handicraft. Okay, let's have a look at the case. This is 1996 case, a quite old case. It involved a young officer, trainee lah, okay. He became a victim of ragging. I think ragging now still exists kan, even nowadays, all right, in certain for example, in like this lah here. Or okay, so he was kicked in ear. What happened? Okay, when he was in the training, he was kicked in ear. Okay, very specific here, the limb, ear. Okay, we have 10 minutes left. When he was on the ground, okay, and then he was being tortured, he was being punched, okay, and when the case was brought to the court, this is the reason, okay, he became deaf actually. It caused him deafness in the right ear and mild deafness in the left. So he almost left his hearing ability, the important sense can of everyone here. So the court actually, give judgment for him, and the court held that although he was weaker and lower in the rank, obviously those who was responsible of ranking here, of course, superior lah in terms of ranking. But the court said that a young officer is still entitled to self-respect and dignity. I mean, every one of us here has our own dignity. Okay, we have self-respect here. So he was undergoing training. So he shouldn't be tortured in that. Severely like that. Okay, so he won the case, and he was awarded with aggravated damages. Okay, this is another case. This one relates to defamation. Okay, we are going to learn defamation later. We have few slides to be discussed. The case is Janting. Okay, take note of the spelling, Tjanting, but I think the pronunciation is Janting, silent T, okay? Silent the first T. Janting Handicraft, Sdn Bhd and Utusan Melayu, reported the year 2001. This is appeal case. So who were the appellant here? The appellants were the Utusan Melayu. Okay, the appellants were the publisher, editor, journalist, and printer, okay, respectively. So 4 people here. of a monthly magazine called Wanita. Not sure whether it is still in existence, because nowadays all the printed magazines or newspaper almost extinct. I mean, everything is online. All right, so now the first respondent, okay, Janting Handicraft here, they carried on business of manufacturing batik material. So they are batik producer. Okay, and the second respondent was its managing director and its alter ego lah. All right. And the respondents, okay, this Janting Handicraft, they were commissioned by the MITI, Ministry of International Trade and Industry, to do what? To supply batik costume, okay, to all APEC leaders, okay, who attended 1998 APEC meeting. Okay, I think Malaysia was the we became the host country lah for APEC in 1998. And then the respondent, Janting, claimed that okay, the appellant's Bahasa Melayu article, okay, in the magazine had in their natural and ordinary meaning meant and were understood, okay, to mean that respondents produce unsightly batik. There was certain article written by this magazine Wanita, and there was comments lah basically. I mean, critics mean that oh, this batik was so ugly, unsightly batik. And then another allegation here, okay, claimed by respondent here, second respondent also had brought shame to the country because very, very ugly batik. So basically, you tarnish the country's good name lah, basically here, right? So brought shame to the country by allowing world leaders to wear unsightly and ugly costume, okay, made from those batik material. Respondent claimed for damages for slander of goods, okay, under defamation, libel as well, and they claim for aggravated damages because now I mean, it affects their reputation. Okay, so something, it's not really physical injury, okay, it's injury to the mental lah, yeah, basically. All right, so the court agreed, okay, they managed to win the case, convince the court. So the court awarded the sum of very big amount, 700,000 as damages as for a libelous article, okay, published in Wanita magazine. And then the court also awarded 300,000 as aggravated damages. Meaning here 700,000 plus 300,000, 1 million in total. Aggravated damages for distress and embarrassment suffered lah. Yeah. But when the case went to appeal, because this is an appeal case, okay, the court reduced the amount. They still won the case, but the court reduced the amount. The total of 250,000, 1/4, okay, not really 1 million. So for the appeal case, the report is made in year 2005 lah. Okay, that's for Janting. So we are done with the first 4 categories. Now we are going to look at general and special. But general and special we are going to discuss thoroughly in detail when we discuss about personal injury. But now this is some of the introduction or the general rule, okay, which is applicable to general and special damage. This is the comparison, okay. And this is taken from the case of Sam Wan Hong and Dr. Kadir Ibrahim Shah, 1981. This is judgment by federal court. So that's why it's very important. So the federal court make comparison, sorry, all the backgrounds. Make comparison between general and special damages. So for general damages, the word general here, normally it is unliquidated. What does it mean here? We cannot really tell the exact amount. Can we say, oh, this kind of injury, 1,000? Okay, so exact amount cannot be quantified. So it is usually presumed, and it represents artificially the gravity of loss. I mean, the more serious is the loss, then we give you more, but we cannot tell you, is it the actual amount here? For example, when the court allows compensation claim for pain and suffering. I mean, how painful is pain here? Is it 1,000 pain, or is it 1 million pain? We cannot really tell. But for special damages, it is known as liquidated. Because why? It is capable of pecuniary assessment. We can tell exactly. So it's not really presumed. It has to be strictly proved. For example, medical expenses. Okay, you have to produce the receipt, okay, of future medical. We can calculate how much, okay, you have to pay. Right, and even loss of wages, salary, or future loss of earning, we have specific formula. We can tell how much that you are going to suffer for the losses. But for general damages, we cannot really tell. Okay, it is unliquidated damages. Okay, and in Sam Wan Hong and Kadir Ibrahim Shah, appellant was injured in a road accident. So we are going to deal with many road accident cases. So what happened to him? His right leg below the knee was amputated. So he became disabled. So the court held that, yes, there was an accident, but then plaintiff was also to be blamed, not really 100% on the part of defendant. So 25% to be blamed here. Okay, so cannot get the full amount of claim. So on 100% liability, the court awarded him special damages of 2,000 plus here. For out-of-pocket expenses. I mean, the one that you can really support with documentary evidence, receipt, whatsoever. And then those days, they have pre-trial loss of earning. But nowadays, we combine, okay, pre-trial, post-trial, okay, and another 25,000 here for loss of earning, salary. And general damages, pain and suffering, okay, he was awarded 35,000, okay, 1981, so big amount. And then loss of amenities, later we learn what's the meaning of loss of amenities, 12,000, 12,000 for loss of earning capacity. And then all this amount, we total it up, and then we have to deduct by 25% because he was also responsible to the injury by way of 25%, okay? And this is, this is the part of the decision of federal court here. Okay, so the court approved the judgment, and the court make it clear, okay, the distinction between special damages as well as general damages. So, this is the reproduction of the earlier slides. This is the full sentence lah, basically here. So we are done. Okay, I stop sharing for a while. Okay, we are done with the first part, okay, of the topic damages.